Right, good afternoon, everyone. I'm just going to get going with the introductory part as people carry on joining us. There's a number of people who are coming today, understandably, because it gives me very great pleasure to welcome you to our third talk of Trinity Term for our Lunchtime Fellowship Seminars. And this week, we have Professor Adrian Briggs. Now, Adrian is the Richard Gozney Fellow and Tutor in Law at St Edmund Hall and Professor of Private International Law in the Faculty of Law. But he came to the Hall as a tutorial fellow in 1980. So he has admitted at least 41 cohorts of law students, but probably many more if you take into account all the other BCL and other degrees. So this is an incredible record, and understandably, if you look at our annual Hall magazine, Adrian is right at the top of the list now as the most senior fellow. And no doubt has seen many changes in the Hall over this time, including, I think, 5, maybe 6 heads of houses. I couldn't quite work it out, so I stopped at that point. I also note that Adrian, when I looked at his CV, he also did his undergraduate and postgraduate degrees in Oxford. So even though at another college, I think you've been in Oxford around 45 years, maybe more. But during this time, Adrian has been an incredible tutor, but also prolific in writing a number of excellent monographs. And I've just been scanning some of them this morning. But for me, it's the comment that he wrote associated with one of his most recent books that made me smile. So this book is entitled Private International Law in English Courts, and it was published in 2014. And it was intended to be an up-to-date synthesis of European law and English law as they regulated the subject. I think, Adrian, you wrote this comment. It is fair to say that the abrupt decision to resign membership of the European Union has not been good for sales. I could hear your voice in there, so I thought it must be you making that comment. So without further ado, I will now hand over to Adrian to talk on Snakes and Ladders, 40 years of trying to make sense of the law. Adrian.
Thank you, Principal. No PowerPoint or anything like that from me, I'm afraid. I learned my trade long before electricity was invented. Previous speakers in this series have opened our eyes to the diversity and challenge of topics in their ongoing research. From a lawyer who, after 40 years of service to college and university, is about to join the ranks of the former people, you may expect to hear that the perspective is rather different, that there is rather more visible in the rear view mirror than there is through the windscreen. And you may fear that none of it's interesting. I shall try in the 40 minutes that follows to try and show you why this is not so by offering a sketch of the most important part of my work on the law, or what I think is the most important part. It is, though, a plainer tale than some others you've heard this term, for the window that I shall open is, unlike those talks that we had earlier this term, a window into an uncomfortable present rather than a romantic past. It's been said that, as with Anglo-Saxon literature, academic writing about English law is mostly a literature of lamentation and complaint. Been there, done that. Most of my academic life has been spent in and writing on private international law. That is to say, the rules and methods applicable to civil matters before the English courts in which there is a foreign component to the story. This may be seen, for example, when one or more of the participants in the litigation is foreign, or when one or more of the material facts in the story took place or may take place overseas, or was or would be done by reference to a foreign law, and so on and so on. In short, whenever there is a non-English element and there is reason for the court to take account of it. In its entirety, the subject tells us who may be brought before an English court to answer a civil claim, which country's legal rules will be used by an English court to regulate the procedure and determine the merits of the dispute. It will also tell us what is the effect in the English legal order of the judgment of a foreign court. And there is a lot of it. And because there is serious money to be made from practicing it, there are rather few of us who use our time in the universities to think and write about it, and we do rather complain. Let me focus then on one aspect of the rules governing the jurisdiction of English courts in civil claims. That is to say, the rules which explain when a defendant, a person that you wish to sue, may be summoned at the behest of a plaintiff before an English court. That is, we are dealing with a part of a part of a part of a part of a rewardingly complex subject. Now, on this, the common law of England on the point is as simple as it is clear. If a would-be defendant, whether that's a person or a company or even a ship, is in England, the plaintiff, whoever he or she is, and no matter where he or she comes from, has the absolute right to serve a writ of summons to require the defendant to appear before the English court. If the defendant so summoned is content to defend the claim raised against her in England, well and good. The court will adjudicate, though, as I suggested, it won't always do this by the application of English domestic law. But the defendant may not be quite so content. She may fear that the terrible cost and terrible trouble of trial in London is more than she wants to put up with. She may fear that she may not get the right answer, or at any rate the answer she wants to receive, from a judge in England. Or she may simply want to frustrate the plaintiff and wear him down. To this end, she may ask the English court to exercise an inherent discretionary power which it has to refrain from hearing the claim. She may contend, for example, that the arguments for dealing with the case before an English court are outweighed by those factors which suggest the matter really belongs in a court overseas, has its natural home before a foreign court. It surprises many who don't know to discover that no statute or other written law regulates this judicial power. The law is to be discerned by reading the authorities and from thinking about what they mean, reading the judgments, thinking about what they mean. And it surprises some to discover that this particular judicial power, although it's of ancient ancestry, only really came to life, but boy, did it come to life when it did, 50 years ago. I should point out, for completeness' sake, that there are, of course, rules for bringing before an English court a defendant who is not to be found in England at the moment the proceedings are to be begun, but these are contained in legislation, not in rules of the common law. So we'll say no more about them for the moment, but we'll focus on the case in which a claim is made against a defendant, the person you wish to sue, who happens to be in England at the point you wish to sue him or her or it. This common law package, therefore, comprises rule and discretion. The rule, the presence rule, that if you are present you can be sued, reflects the common law's fundamental respect for territorial sovereignty. It admits and it avers that the legal and judicial power of a sovereign over a person or a thing within that sovereign's territory is in principle absolute, unquestioned. The discretion, the judicial power, is its natural concomitant. We now accept, and we behave as though we have always known, that so broad a jurisdictional rule needs a subsidiary control mechanism to allow the court to decide whether to exercise or not exercise the jurisdiction which the plaintiff has invoked. And we trust the judges to define, develop, and deploy it. Now, this new intense focus on whether proceedings should be allowed to continue before an English court re-energized an ancient idea that had lain dormant for a very, very long time. That is, a judicial power according to which an English court may order people who are bringing proceedings before a foreign court or threatening to do so to stop what they're doing or else. Today, I think we'd probably call that kind of development a variant. There will be more to say about that. Now, this approach to the jurisdiction of our own courts is reflected in the way we look at judgments given by foreign courts. The basic rule of the common law is that if the person against whom a judgment was given by a foreign court was present within the territory of that foreign court when proceedings were instituted there, we will in principle regard the decision of the foreign judge, by which of course we mean the adjudication in the name of the foreign sovereign, as being conclusive. And we may well enforce that judgment here if the plaintiff asks us to. But if the person in question was not within the territorial jurisdiction of the foreign court, a subsidiary framework of rules may still allow an English court to conclude that we should hold the parties to the terms of the foreign adjudication. Perhaps they have agreed, or can be seen to have agreed between themselves, to abide by and accept the determination of the foreign judge. And if they have, we should hold them to their bargain, and so to the terms of the foreign adjudication, and if not, not. Here too, this body of subsidiary rules has generated a surprising judicial power to order people who have obtained judgments from foreign courts to take no steps to enforce them, or indeed to undo any measures of enforcement which they had already taken. This is a very live issue in today's law, and there is profit in working on it. And almost all of this law was made by judges. All the statutes ever did, all Parliament ever did, was tinker, timidly and respectfully at the edges. Now, this broad scheme of how we look on the business as our courts do is accepted and followed in almost all of the common law world. In practical terms, that means it is accepted, broadly at least, in pretty much all of the Commonwealth, plus Hong Kong, Ireland, and the United States. And that makes quite a large intellectual community. Now, of course, each country within this intellectual community, which received the common law, but then made it its own, works out the details for itself, makes its own changes to suit its own conditions, resists the changes made by others, sometimes rather sharply. And sometimes, just to make a peripheral point here, sometimes when one sees, for example, courts in other parts of the Commonwealth in which judges much less well-resourced than we are, having to interpret the English common law, you're rather reminded of the way that the Anglican Church works overseas. There are places where they still adhere to the old true faith and where they regard what goes on in England today as some kind of modern aberration. But all across the common law world, whenever a court applies or interprets any of this material, it provides new data for us all. The fundamentals have hardly been shaken at all. And as is the way with families, when common lawyers from the four corners of the world talk to each other, they take for granted notions which outsiders and onlookers might find to be rather peculiar. Now, when we joined the common market in 1973, there was, for people working in this field, a prolonged period of phony war. I received my instruction, as the principal has said, in 1978, while a graduate member of Hertford College, and I started teaching and writing here in 1980, and at no point was any serious mention made of European law. The impact of Brussels on this subject was not felt until 1987, but when the blow fell, the task of dealing with it absorbed all our energies, and here's the reason why. The EEC, as it then was, had the idea that its fourfold principle of the free movement of goods, of services, of capital, and of persons could and should be extended to court judgments, so that it will be as easy to enforce a judgment given by the court in London as it would be one from Lille or from Lisbon or even from Liverpool. Who dare say which of those three is the more startling prospect? This free movement of judgments would reinforce transactional confidence, so reducing the cost and risk of doing business across the community. would increase legal certainty so people knew where they stood, and for some who were keeping their cards close to their chest at this stage, edge us just a little closer to a form of legal union. Now, one historic reason for wariness about generally enforcing judgments of foreign courts was that foreign courts had such weird rules of judicial jurisdiction. English law, as we have seen, allowed, and substantially still allows, any person, wherever he or she comes from, to sue any other person who just happened to be in England at the date proceedings were to be begun. No restriction of nationality or of anything else came into it. In France, the Civil Code provided, and still says, that a French citizen has a right to sue any person at all before a French court. In Germany, the Code of Civil Procedure meant and means that a person who has property in Germany, say you left your umbrella in a hotel in Hamburg, could be sued in Germany. Now, if this was all it took for legal proceedings to be begun, no wonder we were all wary of judgments which were derived from them. So how? The brilliant idea was to develop and lay down common rules of court jurisdiction to regulate the beginning of litigation, so that where the matter counted as European, the jurisdictional rules of the courts would be uniform rather than diverse. This would mean, so the reasoning went, that judges from courts in other European states would be accepted and honoured because they would have been based on rules about proper jurisdiction, proper adjudication, which were substantially the same as ours. Our new ones, of course, not our native ones. But we would recognise them because we would recognise them as really like ours. And this was done. It was done first by a convention between the contracting states, and then later on remade as a regulation by the legislative organs of the European Union, as it had then become. The whole lot came whomping down on the national legal systems of the member states, to which fell the task of fitting this new material into the corpus juris, into the whole body of legal rules, by which a court exercised judicial power over those who might be brought before it. I say, fitting it into, because this new material did not simply sweep away the traditional rules. Not all foreign elements are European. These new rules were to apply when there was a sufficient basis for European regulation, not for application when none was. And if that sounds rather vague to you, it should, because it sounded rather vague to us as well. Now, these new rules were made in Brussels, not in London. Those who drafted them looked at the common law, and no doubt at other things, and were appalled by what they thought they could see. They saw, for example, the rule defining the jurisdiction of English courts, the so long as you are present in England, you can be sued there rule, as something which was so crude it was hardly a rule of law at all, just, well, geography. They saw, or thought they saw, an enormous amount of discretionary power asserted by judges who were simply trusted to behave. They were baffled by the idea that an English judge, with authority to adjudicate, could tell a plaintiff that he or she would not be allowed to proceed with the case in England because the court thought it belonged somewhere else. And that if he or she wished to try their chances before a foreign court, that was a matter for them. And if the people looking in were baffled by the thought of such discretionary judicial power, they were slack-jawed in amazement that common lawyers could view such a thing not only as the lubricant that made the wheels go smoothly round, but actually as the jewel in their legal crown. Jewel in their wig, perhaps. And to pick up a point that I made earlier, the idea that an English judge might interfere directly or indirectly in proceedings before a court in another country was to them incomprehensible. For example, if the German legislator has authorized a German judge to hear a case, the idea that a judge in the Strand should find fault of any kind or on any pretext when a plaintiff calls on the German judge to adjudicate was simply inadmissible. The idea that an English court should not only find fault but act on its conclusion and seek to prevent the proceedings before the German court was intolerable. And as none of these English rules was to be found in a statute, it all looked to them like secret knowledge, known to those, well, let's be honest here, known to those of us on the inside, but impenetrable for those on the outside. And almost everybody else was on the outside. By contrast, these sleek new European jurisdictional rules would set out in detail when and where in Europe the defendant could be and could not be sued. Anyone would be able to read the statute, which would be the law in all places and everywhere the same. No judicial discretion would distort the words on the page. Anything which looked like an attempt to allow a judicial power to modify the operation of the rules would be denounced. All legal systems will be treated with equal respect. One begins to see how these two systems of rules are uneasy bedfellows. There is little doubt that national rules about the powers of courts and of judges are coloured by national history, and no two histories are the same. What, though, was required of English lawyers in particular was that they absorb this metric material into a legal infrastructure which was imperial, not by design, but by nature. What, you may ask, could possibly go wrong? Well, to begin with, pretty much everything. Although we didn't realise quite what we were doing, and I think that's true, we didn't, we tried to read all this new material and all this new process as though it were contained in a text drafted in London and enacted in Westminster by lawmakers who saw their function as being the improvement of English law. That, after all, is the way we'd been trained. And we were rather vexed when other people didn't see it our way. Now, when it comes to interpreting text, you do not need to have an advanced degree in postmodern literary theory to know that this is unlikely to be the path to enlightenment. Next, we tried to explain that much of what people told us that they could see in our system of law and procedure was actually an illusion. Let us revert to the example just mentioned of proceedings before a German court which, let us now suppose, the plaintiff had contracted with the defendant not to bring in Germany. Contracts often contain provisions by which the parties agree where they will and will not sue each other, and these things are important. So let's suppose the parties made a contract and they provided in it that proceedings would be brought in London, therefore that they wouldn't be brought anywhere else, not therefore in Germany. Now, nobody doubts that it's the sole prerogative of the German legislator to define the public powers of a German judge, and by natural extension, to define when a person has the right to call on a judge to exercise that power. But, said the English, that's not the point. If the parties have made a contract by which they promised each other not to invoke the available power of a German court, it's perfectly proper for an English court to insist that they act in accordance with that agreement and to impose sanctions upon them if they do not. Nobody is criticising the German court, of course, but the fact that the plaintiff wrongdoer is perpetrating his wrong, breaking his contract, by suing in Germany does not put him beyond the reach of our courts. It doesn't give him some form of invisibility cloak. No doubt a German court could also enforce the parties' agreement if it wanted to, but so what? For the English court, to enforce the parties' agreement does not interfere with the jurisdiction of a German court. We have no view about the jurisdiction of a German court. We have no view about it. What we do is we put on our blinkers and focus on and only on the private bilateral relationship between the parties, and we enforce that. We are not distracted by the bigger picture because the smaller picture contains everything the judge needs to know. Now, reasoning of this kind makes perfect sense to a lawyer trained in the common law tradition, at least if they've been trained properly. To someone who does not have that training, it probably looks like common law chicanery, as though the English courts are doing indirectly something which they dare not do directly or openly. They are interfering with proceedings before a foreign court, pretending that they're doing the very opposite. And although this example can be multiplied 100-fold, this really is the point. The way a court does its duty, the way it frames the issue before it for judicial decision, will vary from tradition, from law to law, much more than one may initially suppose. Let me repeat from the German example. If the defendant objects to being sued in Germany, the German judge will say, the question I have to consider is whether the sovereign has vested me with its power to hear this case. If the sovereign has, my duty is to adjudicate. The English judge will say, if called upon to prevent the proceedings in Germany, the only question I have to concern myself with is whether the parties agreed and bound themselves to each other not to bring these proceedings. If that's what they did, I can and I should order them to do what they promised. Now, each question, each way of looking what the judge has to do makes perfect sense within its own system, as writers on each side of the debate made furiously clear. But when they're put alongside each other, please excuse me, the result calls to mind nothing so much as the noisy imagery, as is said in the East, of chicken talking to a duck. Yet at some point, it dawned on us all, right across the continent, here as well as there, that where all this newly made European material was concerned, we were in fact all in the same boat, and we'd be better off rowing together. And when we did, we surprised ourselves. We came to see and came to admit that where we were all working with a common text, whether this was a statute or a court judgment, there was a real risk that comprehension was being coloured, and coloured too much, by the individual reader's legal cultural background. We reminded ourselves that the interpretation of a legal text is both an art and a science, and that all conclusions are provisional. In this working together, or at least working in respectful alignment, we actually found we had more in common than perhaps we realised. Now, this was the product of us looking at texts which had been handed down or handed out to us for us to work with, texts which were, for all of us, foreign. But about the same time, across the channel this time, some judges were noticing that there were aspects of common law thinking, for example, that it can be legally wrong to do something which is lawful in the place where you're doing it, but that idea might play a useful part in their own legal systems. Here, I think, it is significant that the creativity and the openness came more from judges who have to deal with real problems, and rather less from professors locked away in institutes and asylums with theses, theories, reputations, and a motley collection of honorary doctorates. Judges have to deal with the real world. Let me offer you two examples. In 2002, the Cour de Cassation, the French Supreme Court, concluded that it was possible in French law to order the creditor of a company which was insolvent administration in France to not bring or to stop bringing proceedings against that company in Spain, proceedings which the creditor was bringing because he thought the company might have assets there which could satisfy his debt. The French court took the view that he could be prevented from doing this, even though Spanish law saw absolutely nothing wrong in what was being done. That decision and that order was a first for French law. Perfectly common in England, but it was a first for French law. But as they say, ce n'est que le premier pas qui coûte. It's only the first step that costs anything. Or in a slightly more practical way, it doesn't hurt the second time. Then, a couple of years ago, the Bundesgerichtshof, the German Federal Supreme Court, allowed a person who had been sued before an American court in breach of a promise that those proceedings would not be brought, to claim damages in Germany for the financial loss which he had sustained by having to defend himself there. The basis for the claim was a contract to which the parties had made in which each had promised the other not to litigate in America. The German judges took the view that the issue was not one which was for the American court to resolve. They could perfectly well enforce the parties' agreement themselves and order damages to be paid, even though that issue had been raised before the American court, and even though the agreement the parties had made was about the jurisdiction or not of the American courts. Now, English courts, one might say encouraged by English academic writing, had been doing this for some years. But in other words, and in each case, and these are just examples, though they're really important ones given the courts from which they came, foreign courts at the highest level were seeing something useful, not previously appreciated, in the way the common law goes about its business. That was then. And of course, it worked the other way as well. Common lawyers started to open their minds and to see that there was perhaps another point of view about the things that we took for granted. For example, we came to accept that if a statute was framed and intended by its legislator to be a full, perfect, and self-sufficient statement of the law, it might not be appropriate to subject its operation to the kind of discretionary judicial power on which our courts otherwise depend. It might not be the right way to respect the sovereignty of the particular legislator. And we came to see more clearly and much later than we probably should have done, that the way we framed and narrowed the issue before the court for decision was, though perfectly sensible, not the only legitimate point of view. In another version of the German case, this time more recently and more significantly, a judge in Sicily was deciding, perhaps a little more slowly than one might have liked, whether she had been given jurisdiction to try a case which had arisen from the collision of a seagoing ship with the jetty at the port of Syracuse. She may well have been nonplussed by an order sent out by the High Court in London, addressed to the party who had raised the claim before her court, directing it to abort the proceedings. It's hard to think that she would have been reassured to be told that this had happened because the English court considered the parties to have agreed to settle their differences by commercial arbitration in London. The English court would have threatened the party addressed with a ferocious penalty for disobedience, an offer he could not refuse, perhaps. But was it really good enough for an English lawyer to say that all this was being done to enforce the parties' agreement? There was absolutely no intention to interfere with the work and office of the Sicilian judge, and that there was no more to be said. Was it really credible for an English lawyer to say that the English court was best placed to decide whether the plaintiff had bound itself by agreement to proceed in London and not in Sicily? Or that the answer which an English court would give to that question was all anyone needed to know? Perhaps it wasn't. We learned, and we were still learning, to reassess some of the familiar insular assumptions about the way our courts offer their services to those who call upon them. And by these means, the way in which we understood our private international law was affected and was changed. Sometimes this was direct, where a statutory rule simply, clearly and explicitly contradicted and displaced the answer which until then an English court would have given. But other times, and in a way which is subtle or perplexing according to taste, we needed to ask ourselves and to analyse whether, how and to what extent settled law really needed to be rethought, on the basis that this new material received into the English legal order had a penumbral or a ghostly or a shadow effect, which rippled or ramified far beyond the plain words of the statute. Two examples as time is getting short. First, rules of English law apply to cases in which there is a claim in contract or where a tort has produced damage. Rules of European law also utilise the terms contract and tort and damage, but their meanings are not naturally congruent with those of English domestic law. Should therefore the English rules be adjusted to reflect or align with the European meanings of and nuances of meaning resulting from the same words. Second, the common law has rules that apply to jurisdiction agreements, which it sees and enforces rather as though they were contracts. European law also makes provision for agreements on jurisdiction, but it does not picture them as contracts, rather as solemn, formal declarations of willingness to be sued before a particular court, but more unilateral than bilateral in nature. Are these two species of a single genus? Or are they institutions whose inherent differences are obscured by their having a common name, false friends if you prefer? A few of us have been working at this, at the conflicting demands and conflicting natures of doctrinal coherence in this corner of the law unendingly. A modern and mundane task for sure, but it has something in common with the ancient and divine work of the ecumenical councils in trying to reconcile views about the nature or natures of Christ. For sure, it meant discarding some legal doctrine which had long been comfortable and familiar on the basis it was no longer suited to the task now facing the courts, metric imperial, as I said earlier. And this thinking and this explaining and all of it needed to be done before these issues cropped up piecemeal as discrete questions in court. It needed to be done to allow commercial operators to know where they stood or to make sensible plans for possible litigation. It needed to be done so that those who use and depend on English law, and so many do, would not be misled or taken by surprise. It needed to be done to help busy judges adopt reasoning that was sound and coherent, and which would serve the broader law as well as it disposed of the singular issue raised by the parties whose case was before them. My own attempt to draw together the threads of several decades of such thinking, and to show how the new corpus juris was far greater than the sum of its parts, required nothing more than an excellent law library, which we have, time, curiosity, and patience, wise and tolerant colleagues, and some contact with legal practice, occasionally to test the strength of the arguments. And it was published as a big Oxford blue-coloured book right at the end of 2014, as the principal said. Evidently, my career as a university teacher did not deprive the world of a promising clairvoyant. When my second edition is put together, and I got a contract, the process of disentangling will be infinitely more challenging and infinitely more dispiriting. It's easy enough to tear the relevant statutes out of our books. Parliament has told us which ones to get rid of, but what then? What are we supposed to do about the less direct influence which all this material has had for 4 decades on the way English law was working? How do we discern, never mind assess, this penumbral, ghostly effect? Are we supposed to think ourselves back to the way things stood at the end of 1986 and treat everything which happened afterwards as being in need of rectification or purification? Are we supposed to ask ourselves how our law would have developed over the last 35 years if we had never encountered any of this European material, tangible and intangible? Or should we assimilate organic changes which may have had their stimulus in European law on the basis they actually improve the common law's offering, no matter what prompted them? I wish I knew. I really, really wish I knew, but I don't. And in 2021, neither does anyone else either. Now, if one asks why it matters, no doubt one starts, this is Oxford after all, by asking what it means to matter. Sigh. I would not claim that it matters more than finding a cure for cancer or COVID or even the common cold. But insofar as the clarity and coherence of English law encourages commercial operators to choose English law to govern their dealings and to choose England as the place for the resolution of their disputes, there is plainly a national interest in getting this right and advertising that we've done it. But for me, it's not business, it's personal. For those few of us who have had the privilege of working in this area, to say nothing of the unparalleled blessing of doing it in and from Oxford, this is our law. This is a precious thing given to us to love and to cherish and to obey. Terrible damage has been done to this law by malice, by barbarism, and by the bearing of false witness. Full-throated Anglo-Saxon lamentation and complaint about how dark the age now is, and how contemptible the behaviour of those who disgrace their positions of authority has never been more apt. The task of making repairs to the body of our law, and of doing so that the damage cannot be seen, although that's impossible, is today as urgent as it is unfathomable. It would, I think, be unthinkable to turn my back on it now, even though it demands something far from the retirement I was looking for. Then again, my real retirement plan, which had been to involve myself in teaching at the University of Rangoon, has been overwhelmed by forces of an even greater evil. So this is what I've been doing. This is what I shall be doing. And these are the reasons why I shall be doing it. It remains to thank you for your attention, which of course I do, and to say Floreat Aula, which also I do. Thank you.